Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. One of the questions I've been asked recently is, I've recently done a family law property settlement. I now need to declare bankruptcy. Will the bankruptcy trustee try and undo my family law property settlement and claw back some of those assets into my bankrupt estate? So the answer to this question is, it depends. In most cases, family law property settlements are left alone during bankruptcy. However, there are some exceptions to this. For example, if there was a non-genuine relationship breakdown or otherwise an abuse of the family law proceedings, which usually arises from non-genuine relationship breakdown, as in there wasn't actually a breakdown in the relationship between the two people in the relationship. So in such a case, the bankruptcy trustee will have a look to see if there was another reason for using the family law provisions, such as trying to keep assets out of the reach of that person's creditors. So one of the questions I'm commonly asked when I say that is, how can a bankruptcy trustee tell if I'm trying to put my assets out of reach of creditors, as opposed to there was a genuine relationship breakdown? One of the things the bankruptcy trustee commonly looks at is what's happening in that person's life at around the time of that property settlement. For example, if legal proceedings had been started against that person, say a week before, to try and recover a very significant debt amount, then that becomes one of the factors to consider if the property settlement was done to put assets out of reach of creditors, or whether there was a genuine relationship breakdown. One of the other reasons, or one of the other things that a bankruptcy trustee will look at in reviewing a family law property settlement, especially one that's fairly recent in the lead up to the bankruptcy, is how the assets were allocated under that property settlement, especially if the order for that property settlement, the court order, is by consent of both parties. For example, doesn't mean that all assets have gone to one party and no assets have gone to the party that who is bankrupt, even though that bankrupt or now bankrupt party has contributed financially to the relationship or other factors. So, in summary, most cases, especially when there's a genuine relationship breakdown, and especially if it's a while before the bankruptcy, most of those property settlements are left alone by a bankruptcy trustee. However, there are exceptions to this, especially if it's non-genuine relationship breakdown or very close to the bankruptcy and there's suspicion by the trustee or evidence by the trustee that the family law provisions were used for the purposes of putting assets out of the reach of creditors.